right. So, sorry about the other day or yesterday, but we are back. We're going to finish up our lecture for Chapter 7, finishing up the statutes dealing with basically Texas-specific law. So, under 11.01557 and .561, the broker who represents a party or who lists property under exclusive agency is going to be that agent of that particular party. Okay, so there are certain minimum service requirements that have to be met, like we've spoke before, and the disclosure of representation that is going to be required is either going to be orally or in writing. There also is going to be the first contact with either the other party or the license holder that is representing the party. This kind of goes back through the agency that we had talked about before. Okay. Now, in regards to the disclosure of agency positions, they have to be written. Okay, so it has to be written statements, and that's oftentimes going to be the IABS form. That's the information about brokerage services. It's going to also be at the first substantive dialogue with the party. So when you have that substantive dialogue, that's when there is the initial dialogue, that's the initial step. It's also not required if the residential lease is 1 year or less. And there is no sale, basically, template that's going to be utilized. And also understand that the party that is represented by another license holder also would be involved. Now, understand in this particular situation, the agency disclosures have to be stated and explained in basically, you have to give it to them at the time that you're having that main substantive notice, okay? So again, you have to make certain that it is clear who you are representing. That is going to be very imperative that you are stating who you represent. Failure to do that oftentimes causes issues, okay? That's where they're coming in on these. Now, of course, understand that in any agency relationship, the duties, of course, is going to be to the selling agent, okay, as well as the sub-agent or the buyer's agent, and the intermediary broker. Now, if the intermediary broker decides to appoint someone, that also needs to be stipulated too. So we have to make certain that all of these duties are explained in detail and do provide the context, basically, of clarification. So, Mr. Eugene, if you're representing Mr. Grossman, we need to make certain that anyone that's involved in that transaction knows you represent Mr. Grossman. If there's not a clear definition in that particular situation, there is failure on your part as being an agent. You're not making your agency relationship clear, and that also can cause issues, okay? So you have to make certain that you are fulfilling your duties and representation and also disclosing this as well. Now, there is the recovery trust account, and if you talk to most real estate agents, most of them are going to end up saying that, here we go. I don't even know what this form is. I don't even know what this account is. And that's a good thing. You want to actually, you'd rather have agents not know about this because you don't want them using it, okay? If TREC is involved in this usage of this account, that means you're in trouble as a real estate agent, okay? So under this recovery trust, it reimburses consumers who suffer damages caused by fraud, misrepresentation, or deceit. So if you know about this account and you've had money taken out of it, that means you yourself have been sued at some point, or TREC has came in and had to deal with some issues. So again, you don't want to ever think about this account. This is like a worst case situation, okay? But it basically, again, it reimburses that consumer if there's damages. If they actually had damages that are caused by fraud, misrepresentation, or deceit, then they can end up accessing this account. Now, the license holder, certificate holder, an employee or agent of license or certificate holder can all in this situation be involved within those deceit, misrepresentation, or fraud, okay? Now, every licensed applicant pays $10 into this account, okay? So every agent is going to pay $10 into this account. And the funds, when they need to be replenished, is that if it's going to be below $1 million, the assessed or license holders will be $10 on the next renewal. So if the amount is less, then the next time you renew, all applicants will have to pay $10. Okay. Now, in order to file a claim for payment in regards to this recovery trust account, the aggregate individual or the person must they have to obtain a court judgment against the license holder or certificate holder, and they have to then give that written notice of judgment to TREC or the judgment debtor, okay? And then it will apply to the courts for an order of payment from the trust account. So they must show that the balance is due after attachable assets are basically, are going to end up being sold, okay? The court orders also from TREC to pay can also be another situation, okay? So all of these in this situation is going to be very clear in regards to the overall understanding. So we have to make certain by all means in those situations that we are ensuring that as we go through these different particular elements that we are fulfilling our duties, okay? Because you do not want your clients filing a claim on this behalf, okay? That's not what you want to end up doing. We want to make certain by all means that the clients are actually ending up in these particular situations. The clients are fulfilling their obligations by getting paid from any judgments, okay? Now, there is a limit, okay? There is a limit in these situations. There is a $50,000 limit per claim, okay? And there is a $100,000 limit in regards to per judgment, okay, per licensee. So in that only makes it worse, Miss Linda.
I'm sorry, I thought I was helping.
No, I just did that earlier.
Okay, I'm sorry.
So in that situation is the $50,000 per limit in that particular situation is what it's going to be. The $100,000 in the particular situation is going to be for the judgment. Okay, so in that particular situation, the $100,000 judgment per the situation is going to end up, we're having a little bit of issues, guys and gals. Hold on just a second. For some reason, the lights.
He told me leave it like that.
The other way, this gets worse.
Do yours,
Try that other
Gene.
one. Okay,
Roll it up.
sorry about that. We're having some issues in here, and so we're trying to get it fixed and everything. So hold on, bear with us for just a second, please. The sun is coming in just at a perfect pace to end up causing issues where it's glaring right on the screen today. All right, that'll be fine. Perfect. Okay, so in this particular situation, understand that, like I said, there's a $100,000 limit per judgment per license holder. Okay. Now there can be disciplinary proceedings can also follow. So not only can they file a claim, but they also, in the same situations, by them doing this, they can also, the licensee can be revoked because of the fact if it's not being reimbursed, okay? So if a licensee, say for example, that Garrett utilizes the recovery trust account. So Garrett utilizes it. Garrett goes over in the particular situation, he uses it, and once he ends up using it, what ends up happening is he goes over in that particular situation. It's for some reason it's just not working.
The AC's blowing.
Yeah, the AC's blowing it and putting the blinds all over where it's letting the sun in. But what's ending up happening in that particular situation is if Garrett doesn't pay back the amount, say that it ends up that Garrett is one that's a $50,000 limit, okay? Garrett doesn't pay it back, he could lose his license, okay? They also charge interest rates on this. So they also, in the same situation, they do charge interest on the amount that's currently out. So if you pay out $50,000, guess what? They still can end up in that particular situation. They can turn around and they can hit you not only $50,000 but also about 18% interest. Okay, so you have to end up paying it back. Also, the revelation can end up in some situation maybe probated with a payment plan. Okay, and if the license holder is basically revoked, if the license is going to be revoked, then no new license until the recovery trust is repaid. So we have to make certain that not only can you lose your license, but in some situations you can also have some other issues. Okay. Okay. Let's see here. All right, so our next one here is that also there must be a display poster informing consumers of this recovery trust account. So all real estate brokers have to be providing, and also it's always best in any transactions that you're dealing with, you provide the consumer information form. Okay, the consumer information form provides this trust information. Okay, it gives them the detail. So you want to make certain that you do provide that as well. Now, there are certain prohibited practices, okay? And what we mean by this is that a broker may not compensate non-licensed holders, okay? So in that particular situation, what ends up happening here is that a broker cannot compensate someone that is not a license holder. So that's like if Stephan right now wanted to give you, Mr. Eugene, some money as a commission split, it's against the law, okay? He can only give you a split, or not even a split, he can only give you money if it's for salary, okay, or maybe a bonus. But you cannot classify it as a commission split. Does that make sense?
Yeah.
Okay? The sales agent may not accept compensation except from their sponsoring broker. So if Stephan was to close a transaction, all right, so Stephan closes a transaction with you, Miss Linda, okay, you're the seller, and Stephan closes it, and you say, here, Stephan, I'm just going to give you the money, okay? Or Stephan says, I want to outsmart my broker. I don't want to pay Justin anything. So here's what I'm going to do. Miss Linda, we're going to put 0 in for the commission, so I don't get anything, but then you give me the commission after the fact.
Can't
Okay.
do that.
Of course you can't. Well, let me say this. You're not supposed to. Could he do it? Well, if he's got connections at the title company and all, he might could. Okay, so you got to be very careful. But a sales agent never can get a check to themselves. Okay, sales agents may not pay commission to another except through the sponsoring broker. So Stephan cannot, in this situation, he cannot go over and end up paying another broker or another agent commission. It has to be through the broker themselves. Does that make sense? Okay. And a broker can only be the intermediary, not the sales agent. So this may not violate laws of agency so long as it's followed along. Okay. Very key in these particular situations. All right. Now, there are going to be grounds for suspension or revocation of your license. Felony conviction or guilty or nolo contrario plea of criminal offense involving fraud can cause you to have your license revoked or suspended. Fraud, misrepresentation, or deceit or material misstatement in a license application can also have your license suspended. Okay. Further, misrepresentation, dishonesty, or fraud when buying, selling, trading, or leasing real property in the name of the license holder's spouse, or a person related to a license holder within the first degree of any type of relationship. Okay, you cannot, in a situation, you cannot be basically being dishonest or having fraud or misrepresentation. Further, a bad check to Trek can also be grounds for suspension or revocation. So that says that if Garrett was to write a check to Trek and it bounces, that's grounds for suspension or revocation. Okay. If they fail to produce records that are requested by Trek, license can be revoked or suspended. If they fail to produce information relating to a complaint, that's further grounds for suspension or revocation. And if they fail to surrender documents that are requested by the owner, can also get you into trouble. That's why it's very important in all of these situations. If TREC asks for something, you get it to them. Okay? You don't get it to them, they don't play with you. They don't play around. Okay? If you also fail to use contract forms that are required by statute, if Miss Linda decides, yeah, I don't like those forms, I'm going to do my own forms, that in itself can be grounds for suspension or revocation. If you fail to notify TREC within 30 days of a conviction or plea of guilty, can basically for any felony or criminal offense involving fraud, also grounds. And if you disregard or violate TRELA, that's also grounds. Again, they don't play around with this situation. Things such as being late, not fulfilling, if TREC asks for something, they're not going to play around with you. They're not going to be nice, okay? TREC's going to be pretty much solid, okay? That's why I always tell my agents, and I stay on top of them on everything. Because when you're going through this, TREC does not play. TREC does not play. And they will take your license from you in a heartbeat, okay? It's when it comes to renewing your license too. They don't play around. You have to be in communication with them. You can't just think you're going to wait till the last minute, okay? Any acts that are negligently or incompetent, okay? So say that Stephen decides that he's going to go and work in Dallas. He's going to sell houses in Dallas, but he lives in Bryan College Station. Well, guess what ends up happening here? Well, Stephen, you go over there, you're acting in that situation. Are you competent in Dallas? No. But he's going to say, but I know how to write contracts. That's great, Stephen. But are you familiar with that market?
I don't know the area. I don't know the MLS they use.
So you basically are incompetent in that situation, right? So in that situation, there could be grounds that your license could be taken away because you are not competent in that area, okay? If you demonstrate dishonesty, bad faith, untrustworthiness, that can also be grounds. Making material misrepresentations concerning known significant defects or failing to disclose those significant defects can also provide you for grounds for suspension. In regards to influences with false promises, you never, like I was talking about this earlier in one of my other classes, you never, never, never overpromise. I hear agents all the time, oh, this deal, it's going to get done. I promise you, it's going to get done. And we promise you, I'm going to get you $5,000. And I promise you, I'm going to get this. And I promise you, I'm going to get that. And I promise, and I promise, and I promise. What's the problem with that, Miss Linda?
It ain't gonna happen.
Does real estate ever work the way it's supposed to?
No,
Does every transaction work perfectly?
no, because of the fact kinks can happen really fast. Sometimes within splits of seconds, things can change.
Exactly. Like I told my students in another class, you under-promise and over-provide. You under-promise and you over-provide. If a client asks you, Stephen, can this be done today? His response to me, probably it's not going to happen. Let's shoot for tomorrow. And if it happens to get done today, what do you look like now, Stephen?
You look like an eggplant.
That's right. Okay. So you never promise something. Okay. In the situation also, okay, if you fail, let me go back for a second. If you continue to misrepresent or make false promises, or if you fail to clarify which party is being represented, or you receive compensation from more than one party without consent of all. There are some crooked people out here, y'all, that try to get compensated by everybody. You can't do it, okay? If you fail to account for funds belonging to another, you put that money in your pocket or you don't give a proper accounting, that can get you into trouble. Commingling funds, taking money, putting it into your account that's not actually yours. Making payments to a non-license holder. Fails to specify the definite contract termination date. If I don't put a termination date in my contracts, guess what? That's ground for suspension. if there are going to be profits on expenditures made for the principal, okay, you cannot be doing that. If they solicit, sell, or offer property through lottery, solicit, sell offers of property by means of deceptive practices, or acts as both broker and the undisclosed principal. All of these are ways, unfortunately, that people have utilized this over the years. You notice I always tell people, there's a lot of these on grounds for suspension, and the reason is somebody has done them, okay? And that's what can put you in there. Mr. Grossman, what's this word right here?
Guarantees.
Can we do that?
I wouldn't.
What do I tell my agents in this office? Do they always guarantee stuff?
No, never do it.
Why do I tell my agents, Miss Linda, not to guarantee stuff?
There's a possibility it ain't gonna happen and it's gonna make you look like a big fool.
Yeah. Do you know what's going to happen in the future?
No.
I tell my agents all the time, if you know what happens in the future, then I need to talk to you so I can end up getting the lottery numbers. Okay? So if you know the future, let me know so I can go ahead and I can get some money. All right, and I can retire. But no, guarantees future profits. You cannot guarantee that.
Can't they sue you for that as well?
Yes, sir.
Like if you guarantee that?
Yes, sir. You do not ever guarantee future profits. You don't know what's going to happen. You have no idea, like I don't have any idea. Okay? This next one's my favorite. If you place a for sale or rent sign without the owner's consent. That's my favorite one of all of them. Somebody had to have walked around and just decided, I'm going to put signs up around these places. Can you just imagine that? You get home, Miss Linda or Mr. Eugene, get home tonight, and you get home and you look and there's a for sale sign in your front yard?
I would be furious.
Yeah. Okay? You can't do it. If you offer property without the owner's consent, that also has happened before. Agents will go out and say, yeah, we can sell this house. Never even talk to the owner. Okay? Wouldn't that be nice? We just go around, Stephen, and we just randomly pick houses and put offers in on them. That'd be pretty cool. We'd be in business a lot, wouldn't we?
Yeah, we probably owe a lot of money too.
Yeah, Miss Linda.
We actually had that happen when we purchased the property here in Bryan College Station. Another agent came to our house and it was like 3 days after we had closed. And that actually happened to us and we said, we don't know what you're talking about. We're not interested. I don't know where you're getting that information from.
Wouldn't that be nice? If you offer, you offer property on terms other than what's authorized. Can't do that. Okay? If you induce a party to break contract to obtain a new one. That's a key one. And let me tell you, there's a lot of agents, I'm just going to tell you, there are a lot of agents that break that one almost every other day. Okay? Because what they'll end up doing is they'll try to have the parties break a contract in hopes that they will switch over to them. Cannot do that. If you attempt to negotiate sale, exchange, lease of property that's listed with another broker. If you publish misleading advertising, that happens a lot. If you alter an invoice, making it materially inaccurate. Or if you make unjustifiable threat of legal action. You go around and scare people because you're going to sue them when you know you're not. That can also be grounds for your suspension. If you establish employment relationship with a non-license holder who performs acts of requiring the license. If you conspire to circumvent TRALA, fail to provide signed documents upon request, fail to advertise purchaser to obtain title assurance before closing, if you fail to deposit escrow within a reasonable time, if you disperse escrow and trust funds prematurely, if you violate federal, state, or local fair housing laws, or if you disregard or violate TRALA altogether. Can you see the pattern here so far? You can see the pattern. Okay? I tell people this all the time because of the fact is, guys and gals, this happens. real estate agents in this field, just in real estate and all, it is a very cutthroat field. It's a very cutthroat field. But understand, those that are playing basically on this fine line oftentimes don't make it. While they may be a pain in the neck, eventually what happens is they get out of the field. Okay? As long as you play by the rules and you do what you're supposed to do, you'll be fine. Yes, you'll deal with some headaches. I promise you that. But let me tell you, keep pushing forward. Okay? You don't quit. If a license or registration may be suspended or revoked for the unauthorized practice of law, okay? That is drawing a note, deed of trust, will, or other written instrument that may affect the title to or interest in land, advising a person regarding the validity or legal sufficiency of an instrument or validity of title, okay? The license holder may complete the TREC adopted contract forms, either promulgated or approved. They can also complete forms that are prepared by an attorney or forms that are prepared by a property owner, okay? But you cannot give legal advice on those forms. Now, what are some additional disciplinary authority that TREC has? Well, of course, the most important one is TREC may suspend or revoke a license. Okay, they may suspend or revoke a license. The probate suspension, they can probate suspension or revocation. There also can be reprimand, and they can also assess administrative penalties. TREC also can set terms of probation, and probation terms may include regular reporting to TREC, limited scope of practice, or additional education. All right. You do not want to be on this side of the line, okay? You do not want to be on TREC's bad side. Just going to be honest with you. Not a wise choice, not a wise idea, because TREC does not play. Do your job, do it right, and don't do it wrong, okay? Now, if TREC decides that they need to have a hearing, they might end up in the hearing. TREC may propose to deny, suspend, or revoke a person's license. A person, though, is entitled to a hearing that's going to be conducted by the State Office of Administrative Hearings. They also can appeal the decision to a district court if they want to, okay? But again, there is going to be a hearing if there is an issue, okay? Now, TREC may order a license or certificate holder to pay a refund. Now, this cannot exceed the cost to the consumer, but they may be instead of or in addition to an administrative fee. So they may say that you're going to refund a certain amount of money back to the consumer, and that cost cannot exceed the cost to the consumer. But they can also put a penalty fee on top of it as well, and that results from the informal conference order and resulting from an enforcement order, okay? Informal proceedings. Informal disposition of a contested case. TREC and a license holder may enter into an agreed order without engaging in a conference. Or TREC or the license holder may request an informal conference. So there can be in some situations that the issue, if there is a contested case, the license holder and TREC may come to an agreement without actually having a formalized hearing, okay? They may just remedy the situation outside instead of actually having to do a full formal hearing. TREC or the license holder may request an informal conference as well, okay? But again, these are different methods. Now, the informal conference may be in person or by electronic, telephonic, or written communication. The license holder or applicant may be represented by counsel and offer documentary evidence. Again, at least one public member of the commission and 2 staff members, including the staff attorney, have to be present at that meeting, okay? The license holder's attendance and participation is fully voluntary. So the complainant may be present and may make an oral presentation, but is not a party to the contract or the conference. Okay, so we have to make certain by all of these means that we are fulfilling our duties. Okay. All right. Now, at the conclusion of that conference, the commission member or staff attorney may propose a settlement or recommend that no further action be taken. Okay, so if they feel like the case is not strong, they'll let it be. If they feel like it's kind of strong but not great enough to go through to court, then they may just try to propose a settlement. If the license holder rejects the settlement offer, then the matter is going to be referred to the Director of Enforcement for appropriate action. If the license holder accepts the settlement offer, there will be an agreed order prepared and signed and then submitted to the TREC administrator for approval. So those are your options. Again, not probably a wise idea to reject the settlement offer. Okay, it's normally going to be a little bit better than what's actually going to come to you. Now, there can be in some situations that a license may be temporarily suspended without notice or hearing. Sometimes it can be temporarily suspended. And under certain circumstances, if continued practice of license or certificate holder would constitute a continuing threat to the public, they may end up in that situation immediately temporarily suspended until they can figure out how they want to handle the matter. Now, the disciplinary panel, of course, again, is going to be of 3 commission members that will hear that particular case. Okay. Now, again, in this situation, for violating a provision of the Act, an administrative penalty will be assessed for each violation, and it is not to exceed $5,000 for each violation. Again, each day may be a new violation. So understand that in this situation that you could have multiple fees added over multiple days. Okay, so they can, when you violate a provision of the Act, there can be an administrative fee, but not to exceed $5,000 for each violation, and each day is a new violation. So if you have 10 times, there's 10 days, that's 10 times at $5,000, that's $50,000. Okay. Now, the amount of the penalty, of course, is going to be based upon the seriousness of the violations. How serious is the particular violation? Also, what history? Does Mr. Eugene have a lot of history with these particular violations? Is he a repeat violator? Okay. What is the amount necessary to deter future violations? Maybe we might have knocked or hit Mr. Eugene with a $1,000 fine. Well, he did it again. Well, maybe we need to do $5,000. He does it again. Okay, well, we may need to end up finding another ramification to just hit him to the point that it's going to deter him from continuing it. Okay. What's the efforts to correct the violation? What exactly, if you violated something, Mr. Eugene, how did you fix it? What were you trying to do, or did you even try to fix it? And any other matter justice requires. Okay. So this gives you a nice, simple little breakdown here. Okay, really nice breakdown here. So between $100 and $1,500, if you fail to use a contract form, that's about what your fees will be. Okay. If you act negligently or incompetently, it can be $500 to $3,000. Okay. If you engage in conduct that is dishonest or in bad faith, it can be $1,000 to $5,000. Okay. So examples that are listed above are among those in each category of violations. Again, the penalties are going to be per violation per day. Okay. So in that situation, Mr. Eugene, if you you act negligently or incompetently, like I said, let's say that you are showing Travis properties in Dallas, okay, and you're from College Station, and you're showing him properties in Dallas. you are technically classified as incompetent because you are not familiar with that market. And if you show Travis for 10 days properties, you could be sued up to, or not sued, but Trek could assess up to $3,000 per day for 10 days. That's $30,000 for you showing properties in an area that you're not competent in.
What about selling in the area? Like,
Same situation.
so, like, if I have a family member in Houston who wants to sell their house, I can't.
You have to have someone that is knowledgeable in that area that can assist you. Does that make sense?
Okay.
You yourself, if you're not knowledgeable, it's like me going to Florida and trying to sell real estate there. I have no idea.
Yeah.
Okay? You have to be knowledgeable of your area or have a way to show that you're knowledgeable in that area. You'll probably, and Travis probably knows what I'm talking about, you'll get clients sometimes that they want to look in Houston, they want to look in Dallas, they want to look in San Antonio, they want to look in McAllen, they want to look in Amarillo, they want to look in El Paso, they want to look in all these areas. Well, Travis, can you help them technically in all those areas? No. Because are you familiar with all those areas? No. Okay. So in that particular situation, is you have to be very careful in regards to how you're going to handle these particular situations. Now, again, there are certain steps in regards to the imposition of the administrative penalties. Again, investigation will be done in regards to the possible violation. The determination that violation has occurred, as well as notice of the violation that is issued by the administrator, and the summary of the alleged violation, including the recommended administrative penalty or other disciplinary sanction. The right to a hearing to contest the violation and or the penalty can also be some of those matters that need to be addressed. The respondent, that's normally the license holder, may accept the administrator's determination and penalty. That's their first option. They may request a hearing before an administrative law judge of the State Office of Administrative Hearings, who will then determine a violation has occurred and impose an administrative penalty. A violation did not occur. Okay, so that's the option on that one. The respondent or license holder may, of course, file a petition for judicial review of the ALJ decision, and failure to request the hearing before the ALJ precludes the judicial review. Again, non-payment of the administrative penalty, guess what? Goes to the Attorney General. And the Attorney General will use everything in their control to make certain that you do pay. So how do we enforce these penalties and provisions? Well, injunctive action to abate a violation or potential violation can occur. There also can be civil proceedings. Acting as a broker or sales agent without a license, there can be civil penalties and also private cause of action. They're not less than the amount of money that's received plus court costs and attorney's fees, or more than 3 times the amount of money that's received. That's under your DTPA. Here's your criminal penalties. If you are acting as a broker or a sales agent without a license, it is a Class A misdemeanor. You can have up to $4,000 fine or prisoned up to 1 year or both. Okay. You also have certain subsections. 1101.801 states that both civil and criminal liability can occur. They are not relieved by TREC disciplinary action. Okay. Just because TREC takes disciplinary action does not mean that it precludes you from having civil or criminal action brought against you. So you may settle with TREC, but guess what? You can still be sued by the person you injured and may even go to jail for it. So you got to be very careful. 1101.802 states that no liability for failure to disclose information related to AIDS, HIV-related illness. 1101.803 states that a broker is liable for the actions of the broker and associated sales agents. That's why it's my duty to make certain that my agents fulfill their job. Okay. Again, now let me explain this. Say that Stefan in this particular situation, say for example, that you're supposed to get me your contracts within 3 days. That's what your independent contractor agreement states. Stefan doesn't give me the contracts within 3 days. While I am still liable for your actions, he has now negligently failed to fulfill his duties as agreed upon. So if something were to happen, I will be held accountable by TREC. But what can I then end up doing? I can then go after Stefan for failing to fulfill his duties. Okay? So you have to be very careful in that situation that you make certain that you understand. If your broker says he or she needs something, you better follow it, whatever it is. I can't tell you, Ms. Linder, you probably could say, most people that come on to the office, when you give them the contract, do they actually read that independent contractor agreement?
Nope, they actually automatically sign it and date it and go to the next page.
Yep, and don't even look at it.
That's right.
I could actually ask probably most of my agents, and I would say, hey, what's the independent contractor agreement say? I had no idea. Okay?
You could put that we owe you $1 million every time we sign one.
I mean, you never know. I could put anything in there. I told somebody that one time. I could say, my agents owe me $1 million a day, and they would sign it, wouldn't even know. So, and it's not just mine. It's all agents. Because we get in that habit of what, Miss Linda? You just, everybody, it doesn't matter if it's real estate, it's just you signing anything, you just sign. Because you don't want to sit there and read all that stuff. But again, you have to make certain that you're aware of these different situations. Well, think about our contracts that we send to our clients. You send a contract out to them, do they actually read it? 2 minutes later, you get it back.
It's back within 2 minutes.
Yeah, 2 minutes, boom, it's back in your inbox.
Okay. I just need to click. Okay.
Yeah, that's exactly what it comes down to. So there's no, under 1101.804, there's no liability for providing information regarding final sales price or term of sale if for the purpose of soliciting future business, unless, though, it is prohibited by law. So you can provide it, but understand if it's prohibited by law, you can't. So in Texas, you cannot provide sales price and the property address. It's against the law here. There's also what's called vicariously liability, okay? And this is a party, either a buyer, seller, landlord, or tenant, is not liable for misrepresentation or concealment of a material fact by a license holder unless that party knew about the falsity or failed to disclose the party's knowledge of the falsity. Further, a license holder is not liable for misrepresentation or concealment of a material fact by a party unless the license holder knew or failed to disclose it. Neither a party nor a license holder is liable for misrepresentation or concealment of a material fact by a subagent unless the party or license holder knew or failed to disclose. However, a broker is always responsible for the acts and omissions of a sales agent associated with the acting for the broker, even if he or she knew nothing about the misrepresentation or concealment. So that comes back to this situation, and this is where it's very key. So say that, for example, Mr. Eugene ends up, he's sponsored by me, and Miss Linda, you tell Mr. Eugene some information. But Mr. Eugene does not relay it to Travis, the other agent, and he conceals it. Okay? I did not know nothing about the misrepresentation or anything. Mr. Eugene didn't tell me, didn't tell Travis or anything. But guess what? I am always responsible for those acts, even though Mr. Eugene was the purpose.
Because you're the broker, you're supposed to know this.
Because I'm the broker. I'm supposed to know everything that's going on. Now, while I may be held under vicarious liability, I still can do what? I can come back after Mr. Eugene after the fact and go after him for failing to uphold his contractual agreement in the independent contractor. Now, payment of compensation. A person may not maintain an action to recover a commission unless, and here's how you get a commission. There's proof that that person was licensed or was a duly licensed attorney when the services were performed. The agreement was in writing and signed by a person charged or authorized representative, or the purchaser had been advised to get title insurance or have an abstract obtained by an attorney of that purchaser's selection. Okay, so as you can see, that's a lot of material. That's a lot of material for this class, for this chapter. Like I told y'all earlier, this section is the only section that we're going to talk about for the real estate exam, okay, for the Texas portion of it. Remember, your exam was broken into two portions, national and state. This is the state, okay? We just went through everything for the state exam, not the national. The national, that's all the other courses. But Texas specific, this is it, okay? So I highly recommend that you review this slide, you go through, you review any of these things. In our prep course, we'll go in through a lot of detail, but again, you need to be aware of this information that we went through tonight, okay? What we're going to end up doing, actually, let me go ahead and stop this recording.